On June 24th, 2026.
Right.
And we are standing inside courtroom 3B of Florence County.
It's a very busy place.
Exactly. Up on the bench, Judge Seals is in the middle of a trial. He has just sent the jury out for a mid-morning recess.
So they're on a break.
Right. You can imagine the atmosphere, the sudden lull, the lawyers shuffling papers, the quiet hum of the air conditioning.
Yeah, that tension dropping for just a second.
Exactly. And in that tiny, high-pressure window of time, the judge decides to squeeze in a mandatory status conference for a completely different case.
Which is a profound shift in gears, honestly.
Yeah.
Yeah. I mean, judges carry enormous administrative burdens, right?
Yeah.
And they often try to clear their secondary dockets by slotting quick check-ins during these recesses.
That makes sense.
But that creates a highly compressed environment. The judge's primary focus is obviously the jury waiting in the hallway.
Yeah.
So anyone stepping up to the podium for that squeezed-in conference is walking into a room where the predominant emotion is just urgency.
Urgency. And that urgency is the perfect backdrop for what we are looking at today.
Definitely.
The case he calls up in this small window is Anderson v. Eddy and Gamble, case number 2025 CP 21-01381.
Got it.
Welcome to today's deep dive. Our mission for you listening today is to investigate a bizarre afternoon in court where the official public digital record completely fractured from the physical reality of what happened in the room.
It's quite a story.
It really is.
Yeah.
By the time the dust settles on this single afternoon, 2 different resident judges will have completely stepped away from the case. Okay, let's unpack this.
Let's do it. We are going to examine the actual mechanics of the court record today.
Right.
Modern judicial systems run almost entirely on documentation. The public docket is supposed to be the objective truth of a case,
The ultimate ledger.
Exactly.
Yeah.
But we are going to look at what happens when that digital ledger is manipulated or fragmented or just simply left blank.
Which is wild to think about.
Right, and how that distorted paperwork creates a very dangerous structural bias.
So let's start with the opening moments of that June 24th hearing.
Okay.
Judge Seals looks down at the plaintiff, and we need to establish that this plaintiff is pro se, meaning they do not have an attorney representing them.
That's a crucial detail.
Right. So the judge looks at this pro se plaintiff and immediately accuses him of filing, quote, too many motions.
Oh, wow.
Yeah. And based on this supposed avalanche of filings, the judge uses it as his primary justification to skip standard procedures and just force the case to trial.
See, that narrative, the idea of the overly litigious, paperwork-obsessed, pro se plaintiff, that is a very common institutional bias.
Really?
Oh, yeah. The judge establishes right out of the gate that the plaintiff is gumming up the system. He assumes the plaintiff is abusing the process, which, in his mind, justifies an aggressive push to trial.
So if a judge is making that claim on the record, I have to assume he is looking at a computer screen that is just flooded with motions.
Oh, he is absolutely looking at a flooded screen.
Like scrolling endlessly.
Basically. But the mechanism behind why that screen is flooded changes the entire context.
Okay, how so?
Well, the plaintiff had actually documented an anomaly in the system back in May. What we're looking at is a batch override matrix.
A batch override matrix.
Right. On May 6th, 17 historical records on this docket were force-stamped with identical new timestamps.
I am having a hard time picturing how that happens. Like, does a clerk just go in and manually change the dates on old documents?
No. It is usually an automated database function.
Oh, okay.
Court systems frequently upgrade software or they run financial reconciliations.
Right.
When they do, a script, a batch override, can aggressively overwrite original metadata.
Wow.
But it didn't just change the dates. The system fundamentally fractured the filings.
Fractured them.
Yeah. It took single motions, accompanied by single payments, and just split them apart.
Wait, split them apart how? Like taking a single 10-page document and logging it as 10 separate pages?
Not quite. It is tied to the financial coding.
Okay.
Let's look at the mechanics of a filing fee. When you pay a $100 fee to file a motion, that money doesn't go into one giant bucket.
Right, it gets divided up.
Exactly. Statutory requirements often divide that fee behind the scenes, so maybe $50 goes to general court administration, $25 to a technology fund, and $25 to a judicial library fund.
Makes sense.
A properly functioning docket software parses that money internally while displaying a single document to the public.
Right.
But in this case, the system malfunctioned and created a distinct public-facing docket entry for every single financial subcategory.
Okay, wait. Imagine going to the grocery store.
Okay.
You buy a $100 cart of groceries.
Right.
But the cashier prints out a receipt for 4 separate $25 shopping trips.
Yes.
Just to make you look like a hoarder. It's an illusion of volume.
That is the perfect way to look at it. What's fascinating here is that the financial breakdown is the exact mechanism at play.
It's just why.
One single $100 filing fee generated 4 distinct line items on the public docket.
Wow.
A $120 filing generated 5 separate line items, each fragment displayed as a unique motion.
So the judge is looking at this docket, seeing 5 lines instead of 1, and his brain just registers volume.
Exactly. This is a textbook example of cognitive anchoring bias.
Anchoring bias.
Yeah, judges rely on the visual layout of a digital docket to quickly take the temperature of a case before they walk into the courtroom.
Because they're so busy.
Right. So the judge anchored his entire perception of the plaintiff to that inflated line item count.
Which was completely fake.
Right. The narrative wasn't based on the plaintiff's actual behavior. It was based on a clerk's office database fragmentation problem that directly prejudiced the judge.
Before the hearing even began.
Exactly.
Okay, so if the court's software is artificially inflating the docket in one area, making 5 documents out of 1, what on earth is it leaving out entirely?
Right.
Because if the database is that volatile, there have to be gaps.
The gaps in this specific public record are massive. While the database was artificially multiplying certain entries, it was entirely omitting major physical events.
Yeah, we need to talk about the ghost hearings.
The ghost hearings, yes.
There are 2 specific dates, October 27th, 2025, and January 21st, 2026.
Right.
Real events that took place inside the courtroom. But if you search the official public docket for those dates, you find absolutely nothing. No delays, no fragments, just absent.
It's unsettling. To understand how a hearing just vanishes, you have to remember that a court docket is not a passive recording device.
Right. There's no camera just logging things automatically.
Exactly. It doesn't automatically log an event just because people walk into a room. It is a manual ledger.
So someone has to type it.
Right. A human being, a clerk, has to physically type the event into the database. If the clerk fails to enter it, or actively chooses not to, the event basically ceases to exist in the eyes of the public record.
But the plaintiff didn't have a hard time proving these missing hearings actually took place?
No, he didn't.
And the reason why is my favorite detail of this entire case.
It's pretty incredible.
When the plaintiff objects on June 24th and brings up these missing dates, Judge Seals can't deny they happened because Judge Seals himself presided over them.
Right. It's wild. The plaintiff is forcing the judge to reconcile a severe cognitive dissonance.
Yeah.
The judge has his own lived memory of presiding over the October and January hearings, but the official screen in front of him says they never occurred.
So let's zoom in on that undocketed January 21st hearing, because this is where it gets really interesting.
Okay.
This is the moment the procedural guardrails just completely fall off.
They really do.
During that undocketed January 21st hearing, managing clerk Don Pappas actually spoke in support of the defense's position.
Which is a huge red flag. The clerk's office is the administrative backbone of the justice system.
Right.
Their mandate is absolute neutrality. They manage the flow of paper, they manage the calendar. Stepping into an advocacy role is a severe violation of that neutrality.
I am just hung up on the physical logistics of this. How does a clerk even enter the fray?
Good question.
They sit off to the side, usually at a lower desk, right? Does she just start talking over the lawyers?
Just chimes right in.
And more importantly, she wasn't sworn in. Nobody asked her to raise her right hand and swear to tell the truth.
She was absolutely not sworn in. And you were hitting on the fundamental mechanics of due process here.
Okay.
Our legal system is adversarial, meaning it relies on 2 sides challenging each other's evidence.
Right.
For that system to work, any testimony submitted to a judge must be given under oath. The oath attaches legal consequences, perjury, to a lie.
That makes sense.
Once a statement is sworn, the opposing party has the constitutional right to cross-examine the speaker to test the validity of their claims.
But because she was unsworn, the pro se plaintiff was denied the right to cross-examine her, or even respond.
Exactly. By accepting unsworn input from a supposedly neutral court official and simultaneously silencing the plaintiff's ability to challenge it, the judge essentially allowed the managing clerk to join the defense table.
Wow. What did she actually say to the judge during this ghost hearing? Because her statement ties this entire system failure together.
It really does.
Yeah.
During that January 21st hearing, which again does not officially exist on the docket,
Right, the ghost hearing.
Don Pappas explicitly asked the judge if he could stop the plaintiff from filing so many motions.
Wow. The irony is just staggering.
It is.
The managing clerk whose office oversees the database that is improperly splitting one motion into 5
Yep.
uses that falsely inflated visual docket to convince the judge to shut the plaintiff down.
It perfectly illustrates how technical errors compound into systemic injustice.
Absolutely.
The clerk's unsworn request planted a seed. And that seed grew into the exact narrative Judge Seals used to open the June 24th hearing months later.
Oh, wow.
The judge's entire premise for aggressively setting a trial was built on a fragmented database and an uncross-examined request from a clerk during a vanished hearing.
Which raises a really obvious question, Remy.
What's that?
If the managing clerk is practically stepping into the shoes of the defense, where is the actual defense attorney during all of this?
Yes, the absence of legitimate defense counsel is the structural flaw the pro se plaintiff uses to finally force accountability.
Okay.
When Judge Seals tries to push the case to trial, the plaintiff objects by stating the defense is legally in default.
He argues they are in default because they do not have legitimate counsel of record. What does counsel of record actually mean in a technical sense?
So it is the legal chain of custody. You cannot just walk into a courtroom in a suit and start speaking on behalf of a corporation.
Right, you need paperwork.
Exactly. When an attorney takes a case, they file a formal notice of appearance. If they leave, they must file a formal notice of withdrawal. And if a new attorney takes over, they file a substitution of counsel.
Yeah.
This ensures the court, the opposing party, and the public always know who holds the legal authority and the liability to bind that client to a judgment.
But the plaintiff points out that this chain of custody is entirely broken.
Completely broken.
The original attorney, a lawyer named Heath, left the case, but he never filed a formal withdrawal.
No, he didn't.
And the new attorney standing in the room on June 24th, Eugene Nettles III, never filed a substitution.
Nothing. There is zero paperwork bridging the transition. Eugene Nettles III has no formal documented authority to act as counsel of record.
How does an attorney physically get past the judge without the court verifying his paperwork? Does nobody check?
It is a symptom of institutional complacency, honestly.
Really?
Yeah. In many jurisdictions, judges and clerks see the same local attorneys every single week. They develop a familiarity.
Oh, I see.
So if a known local lawyer stands up at the defense table, the court often just presumes the paperwork is in order without actively checking the ledger.
But the pro se plaintiff didn't just complain about this locally, right? He escalated this all the way to the South Carolina Supreme Court.
He did.
He filed for writs of mandamus and prohibition under case number 2025-00290. For those of us without a law degree, what exactly do those writs do?
They are highly aggressive appellate tools.
Okay.
A writ of mandamus is Latin for "we command." It is an order from a superior court forcing a lower government official, like a trial judge or a clerk, to perform their mandatory duties.
Got it.
A writ of prohibition is the inverse. It orders a lower court to stop doing something that exceeds its jurisdiction.
So the plaintiff is essentially asking the Supreme Court to force the local court to recognize that the defense lawyer isn't legally present.
Yes.
And he gets proof. There is a June 5th letter from the Chief Deputy Clerk of the South Carolina Supreme Court. This letter explicitly confirms that Eugene Nettles III is not recognized as counsel of record at the Supreme Court level either.
That letter is the smoking gun. You now have the highest court in the state confirming the exact same paperwork gap that the pro se plaintiff identified in the local courtroom. The defense is operating with phantom representation.
Let's bring all these threads together back in courtroom 3B on June 24th.
Right.
It is a pressure cooker. The judge is trying to force a trial based on the fragmented docket. The ghost hearings have been exposed. The phantom defense lawyer's lack of paperwork has been validated by the Supreme Court.
It's all coming to a head.
Right. And then the plaintiff reveals the underlying context of why Eugene Nettles III being in that room is so problematic.
Because the lack of substitution paperwork wasn't just an administrative oversight.
No.
It was masking a massive conflict of interest. Eugene Nettles III is related to the Honorable Michael G. Nettles.
And Michael G. Nettles is another resident judge of the 12th Judicial Circuit. This is the exact same circuit where this hearing is taking place.
Exactly. And let's explain what a resident judge is real quick. Unlike a visiting judge who might travel the state, a resident judge is a permanent fixture of a specific judicial circuit.
Okay.
They work in the same buildings, they share the same administrative staff, and they operate in tight collegiate circles with the other resident judges.
Right.
So having a defense attorney who is a relative of a resident judge within that same closed circuit creates an insurmountable barrier to impartiality.
So the pro se plaintiff stands in front of Judge Seals and respectfully but directly puts this family relationship on the record.
Yep.
And the result is immediate.
It is. Judge Seals recuses himself from the case that very afternoon.
He steps down and he puts it in a written order. He explicitly cites a, quote, perceived conflict of interest and names the relation to Judge Michael G. Nettles as the reason.
But the fallout doesn't stop with Judge Seals. No, because in that exact same written order, a second resident judge, Judge DeBerry, also formally recuses.
Wow. The docket officially updates at 4:49 p.m. that day. The final entry reads, pending ADR-sanctioned recusal DeBerry. Let's break that entry down. What does ADR-sanctioned mean in this context?
ADR stands for Alternative Dispute Resolution, which usually means mediation or arbitration.
Okay.
By sanctioning ADR, the court is essentially pausing the aggressive push toward a trial and forcing the parties into a structured settlement discussion.
That is a complete reversal of the judge's posture from 10 a.m. that morning.
A total reversal.
And because two different resident judges have now formally recused themselves, what happens next?
Well, the 12th Judicial Circuit is functionally walled off from this case now. Every future hearing will require the state to bring in a visiting judge from a completely different geographic region.
Wow.
Someone entirely outside the local sphere of influence, just to ensure neutrality.
So what does this all mean? It is an absolute systemic reset, forced by a pro se plaintiff who simply refused to accept the narrative displayed on a computer screen.
That's exactly it. And it brings us to the most vital takeaway for you listening right now.
Yeah.
We live in an era where we grant immense authority to databases. If an official government ledger says a document exists 5 times, we believe it.
Of course we do.
If it says a hearing never happened, we doubt our own memories. But this deep dive illustrates that digital records are highly susceptible to human manipulation, technical fragmentation, and institutional bias.
The public record is only as reliable as the clerks who type it and the judges who oversee it.
Exactly.
This plaintiff proved that you can hold a massive institutional system accountable, but only if you pay forensic attention to the actual paperwork and the missing paperwork.
Right. Justice relies heavily on the interpretation of the law, but it relies equally on the structural integrity of the ledger. When the ledger is corrupted, the entire judicial process warps around it.
I want you to think back to that opening scene one last time. 10 a.m. in courtroom 3B. A judge rushing to clear his desk, an unsworn clerk stepping in as an advocate, and a defense lawyer operating without authorization.
A perfect storm.
It really was. This sequence of events was caught and corrected because one person paid attention. But I want to leave you with a final thought to mull over. If a modern digitized public court docket can be so easily fragmented to create an illusion, and actual physical in-person hearings can become ghost hearings that simply vanish from the public eye. Wait, I mean, that vanish from public view?
Right.
How many other historical legal cases out there have an official public record that tells a completely different story than the reality of what actually happened in the room?
It's a chilling thought.
It really is. Until next time.